We'll call this meeting to order, and this is a special meeting of the Oversight Board, and it's for the July the 2nd meeting. May I have a roll call, please?
Board members Zakarian.
Here.
Lansifin.
Here.
Nakasone.
Here.
Ochoa.
Here.
Sheehan.
Here.
Steger. Here. And Chair Raggio.
Here.
Here. I mean, sorry.
And there. May I have an approval of the minutes?
If I can read the report first.
All right.
The agenda for the July 2nd, 2012 special meeting of the Glendale Oversight Board was posted on Wednesday, June 27th, 2012 on the bulletin board outside City Hall. And at 2A is the approval of the minutes for the Special Oversight Board meeting of Thursday, May 30, 2012.
May I have an approval of the minutes?
So moved. Second.
All those in favor?
Aye. Aye.
Hi.
Minutes will be stand as read.
Just to note that I'm abstaining from voting on the because I wasn't here on the on that day.
Thank you.
And it was Board Member Lansifin that motioned and Board Member Ochoa that seconded.
Yes, sir.
At 3A is informational items, legislative update.
Good afternoon, board members. Today we will be, in absence of Ms. Van Meiden, who would normally give you this legislative update, I will do my best to provide you with an update on the pending legislation since we last met, because a lot happened last week, and I'll do my best to bring you up to speed. I'd like to concentrate on 3 bills. The first one is Assembly Bill 1484, which is the budget trailer bill. This bill was printed on June 26th and voted on the following day, June 27th, and chaptered on the 28th. It went into effect yesterday. We did not have a lot of time to, analyze this bill. This is a bill that clarifies some of the ambiguous and conflicting information that was in ABX 126, the dissolution bill. I'll go through some of the provisions of AB 1484 with you. The other 2 bills I'd like to go over are SB 1151 and SB 1156. So for AB 1484, this bill requires that a licensed accountant be retained to go over the successor agency's unobligated cash balances, and upon completion of the review, any unobligated cash must be distributed to the taxing entities. There are aggressive time schedules to comply with some of these new provisions, and this bill also provides the DOF and the counties to be able to penalize successor agencies if we do not comply within the timelines that they have indicated.
You said AB 1484 was approved?
AB 1484, Assembly Bill 1484, yes, it went into print on the 26th, was passed on the 27th, and it took effect yesterday, July 1st.
What is meant by a licensed accountant?
Certified public accountant, CPA.
But that would be separate from. In other words, we would have to solicit.
Correct.
To have one, as we did with attorneys?
Correct.
Okay.
Let's see, let's keep going.
I'm sorry, just the Oversight Board would, or the Successor Agency?
The Successor Agency.
Okay.
Oh, okay.
But when do they need to have that review complete?
Well, let me get to that, because this is, it relates to the ROPS, so I'll get to that in just a minute. Let's see, once the successor agency does pay this full amount, assuming we don't object to it and we don't need to have a second review, we can receive what's called a finding of completion by the Department of Finance. So this assumes we've hired a CPA to review, and we agree that what they say is unencumbered cash agrees with what we think is unencumbered cash. we send the money over to the DOF.
Can I just cut you off? Can I ask a question real quick? When you say "we," that's what's getting me a little bit
Oh,
confused.
okay, I'm sorry.
The successor agency hires the CPA, not this board.
Correct.
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 In fact, I think as you go through this, based on what I saw of the law, and I don't want to skip cut to the chase, but it's almost as though we become
It's a
superfluous.
recording agency.
Because the DOF reserves for itself basically all of the decision-making power.
I'll jump ahead since you brought up the point, but the preparation and approval of the ROPS, as I read the bill, before the ROPS would come to the Oversight Board, you would have a chance to review it, and then we would send it over to the Department of Finance. This new bill asks us to send the ROPS, once it's prepared, at the same time as you receive it and the public receives it, to also be sent to the Department of Finance, the LA County Auditor Controller, and the Administrative Office. So it does give a lot of deference to the Department of Finance in terms of reviewing and approving ROPSes.
And whatever we say, they basically can override it and have the penalties strangle the successor agency.
They are the final approving body.
Mr. Chair, a little bit, what's the word I'm looking for? Well, let me just ask, was there any discussion about doing away with oversight boards? Because again, as was stated, they're going to do an independent review. They're going to start it at the same, probably before we even see it, they'll start their review. Was there a discussion, do you know, as to why? Or should we keep this board intact and this level intact?
It's a hard
And
question.
part of
for
it's
me
a
to answer.
rhetorical question, I guess, but
I think it was an editorial more than a question.
well, no, I
You're
mean, in
making
all
it-
honesty, what are we going to be doing? I'm talking to my fellow members.
Are we relevant?
Are we
Let's say
relevant?
that. And if we're not, then there's no sense in us going on.
I guess we're relevant in the sense that the law still requires that we do this, but
Well, I
that
don't want
was
to be the tail
prompted
of
my
the whip
question.
either on that, but I think it's a fair question, and maybe we ought to go to our local leadership in terms of the Assembly as well as the Senate and ask them.
Wouldn't that be a question that our legal counsel will basically write a letter to the state and say, our board is concerned that their legitimacy of the board has been jeopardized accordingly as a legal counsel for them. I'm writing a letter to see if they're going to stay or something like that. I think the legal counsel will be the best person to address that with the state.
Yeah, Mr. Chair, I would agree that our legal counsel probably needs time to really analyze and research the bill to find out exactly what our authority is. And then at that point, if there's still concerns, we might think about doing something like that.
Mr. Garcia, can you add light to this?
No, I can't, but Mr. Chair,
But he's gonna sit down anyway.
all I was going to say was a couple things. One is that this is a legislative update, so we can't get too far afield of what we want to do. We're still looking at it. I mean, it literally, as Elena said a couple times, it's still hot off the press. I mean, it just came, and we're still trying to look at the impacts and what the impacts are to the successor agency and to the oversight board as well. And as you know, another item on your agenda will be to select oversight board counsel. So that's obviously something that you can ask them, the board counsel, to look at as well and provide an opinion to you as far as what the scope of the role and duties of the board will be after AB 1484.
Thank you.
If there are no further questions, if I can continue highlighting a couple of other provisions. The January to June ROPS, which was our first ROPS, we still believe that we were not allocated funding to pay for those obligations from the trust fund. The county and DOF feel differently because they feel they paid us back in December while the lawsuit was occurring. And our point of view is that we would incur costs, we would receive trust funds, and pay those obligations. AB 26 forced us to list all of our obligations on our ROPS and sort of look forward and pay it all, at the same time. So there's a 6-month gap that we still strongly feel we haven't been paid for. Not only does this
When you say "we," you're talking about the successor agency.
I'm sorry.
Because when you say "we," it makes it very difficult to understand.
I apologize.
I'm really sorry.
That's okay.
I hate to do this for you.
I
This
understand.
is going under recording, and I want to make sure that we're clear. When you say "we," you're talking about successor agency.
Okay, this report, the provisions of AB 1484, when I refer to we, I mean the successor agency.
Okay.
This bill also asks for a review to be conducted by LA County, and the purpose of the review is to determine if there were any pass-throughs to the taxing entities that were not paid by LA County or the successor agency. Again, let me just backtrack 2 steps. Prior to this, we would pay the pass-throughs, and the ROPS, when it was first brought up, was there was some conflicting information about whether to list pass-throughs on the ROPS or not. So we listed pass-throughs on the ROPS, and depending on when those pass-throughs were due, we paid some of them and we didn't pay some of them. So this is to make sure that every taxing entity that was obligated to receive a pass-through amount is given the amount that they're due, and if there was any amount that was missing, this allows the county auditor to, from our future trust funds, to withhold money to pay any back pass-throughs, back owed pass-through amounts. The timing of this review is by next Monday, July 9th. So the county this week is hurriedly reviewing to see if we paid it, to see if they paid it, if there was any taxing entity that still due any monies, and we are to receive a letter by next Monday if there is any amount. If there is, then in 3 days, by July 12th, we need to cut a check out to LA County for this amount. If we do that, that's great. If we don't, then there's 10% penalties that are incurred for this amount being paid late, plus 1.5% for each additional month that the payment is late. So there's strict penalty provisions in this if we don't if we don't pay it, basically.
I think, again, they're talking to the successor agency.
No, I understand that. I'm just trying to understand what dollar amount are we talking about? What did we ask for? What are they saying that we should, is the difference? I mean, those numbers should be given to us, so when you're saying that, do we have any control over what that process is?
I don't think so.
Oh, it's
I
already
think that's
implemented.
how ludicrous it is, because I've been following it as well. We're going to know, we won't know that, and if there's a disagreement until next Monday. And then by next Thursday, we need to cut a check. We believe.
To the county.
For the county, correct.
To the county. I think the successor, and from staff of the successor agency, we believe, and former redevelopment agency, that we've made all those appropriate payments. But we're going to be at the whim of some other entity to say, yes, you did, or no, you didn't.
That
least
would
according
be
to
the
this bill.
Department of Finance in the state,
Oh,
wouldn't
I
it?
think.
LA County.
The LA County.
Or the LA County.
The auditor's office.
It's the auditor.
It's the auditor's office, correct.
The auditors, what is that number? That the auditor's office, do you know?
They're doing their analysis right now.
So on July 9th, by July 9th, they're going to announce what that number is that you have to pay them.
It could be zero, as Mr. Lanzafame indicated.
I understand. And then by July 12th, you either agree or disagree, but you have to cut a check no matter what?
Correct.
Yeah?
Correct.
And if it's the
That's my
13th, you
understanding.
pay 10% more.
And if you don't, you pay 10% more. And then what is the challenge? Does the city have a right to challenge it? And if you win, you don't pay the 10%?
No, unfortunately, it gets worse because the city, as the host city of Glendale, we're supposed to get a July 18th distribution of sales tax, and if we don't make this payment, then that's withheld until we comply.
They withhold your tax, so
Correct.
basically they have a kind of a lien on your
Correct.
taxes if you don't pay it.
Well, and again, we're going to hire legal counsel, I suppose, but I mean, the question's going to be, how is that legal? I mean, I can't imagine that being.
Got to be a due process in reference
You
to
would
what
hope
you
and
have to.
expect.
You have to. I'm not saying if the city is right or wrong. I'm saying that there has to be a due process where you present your case to be able to be heard before any of these happen. So how is that process going to be even? I don't understand.
Just to get ahead of this, we will be reaching out to our county contacts just to see if they have by chance finished our agency's review, and if they have, maybe we can get a couple of extra days to do our own in-house review to see if we agree.
The obligation is zero, then you don't have to worry about it.
Chair, will we be reaching out to our taxing entity partners? I mean, if they're in agreement with our number, should the county be in agreement with it? Or that's not the process?
There's not, I think it would be faster if we contacted LA County, just given the short time frames. I mean, we have the rest of this week, basically.
But AB 1484 is the one that established these dates.
Correct.
Okay.
Now, if there's any balance dues going back to the county, does that affect any of the numbers here?
If there's any balance, this is.
You have to write a check. Let's say if they say you have to write a $20 million check, I don't know what the number is, but whatever amount of check that you have to write, does that affect any of the numbers we've already approved?
Correct, because they would be requesting it from the RPTTF, which is the trust fund, and as I will get into this later in my action item,
Maybe I'm
but
rushing into
the trust fund, all we got is going to go to our debt service. So if this is a large number, we don't anticipate it to be a large number that they would want us to cut a check for, but if it is, it would impact our debt service payments, absolutely.
What other good news did you get, Bill?
Let's see. So going back to the certified public accountants review, and if we agree, there are a couple of positive provisions, and some of these were from other legislation that was happening at the same time but were incorporated into the budget trailer bill. Two specifically, one was from AB 1585, which was Speaker Perez's bill, and this relates to city and agency loans. So if we receive a finding of completion, this bill allows us to enter into agreements with the city of Glendale to borrow funds and to pay it back. That can't start until the following fiscal year, 2013 and 14, and it does limit how we can make those repayment payments to the city of Glendale. So that's one aspect. The second aspect is 2010 bonds. This agency, along with a lot of agencies in California, issued bonds both in 2010 and 2011. What this bill does is allow us to spend the proceeds from our 2010 bonds, which for this agency were about $27 million. In 2011, we issued $50 million in bonds, and this provision does not address that. So we would be able to fund some of our public improvement projects using those bond proceeds.
Do you know what's the government code number that they gave to this AB 1484?
It amends Health and Safety Code section. It's a
in
number
here.
of sections, but mostly starts with. It starts with 34161, which is how AB X126 was
What was the number
codified.
again? The section number?
34161, which is Health and Safety Code section.
Thank you.
On the bond proceeds, I mean, at the end of the day, realistically, they couldn't have used those bond proceeds for anything other than what those bonds were sold for, correct?
Correct.
So it's not as though, because I've heard this already now a couple of times in discussions and even read it in some of the press information. Somebody was doing us a favor by saying, we're going to let you spend those bond proceeds for the things that you told the bondholders that you were going to spend them on. It's like that scene in The Bridge on the River Kwai where they give the prisoners the care packages, but it's their own Red Cross care packages. You know, it's kind of hard to be overjoyed about that fact.
Yes, I mean, obviously, because that's, that's obviously the position that
There
we
would have
took,
been a
we
class
took
action
legally.
lawsuit did they not do that.
Yes, and the only thing I would add, though, is obviously, as you know, the Department of Finance had taken this position, well, if you hadn't executed any third-party contracts pursuant to those bonds, you were not going to be able to use them. So to the extent that they're going to back off of that, I think there's some silver lining there. But you're right. I mean, they're letting us do what
The
we already
litigation
allowed
that
to
would
do.
have ensued would have been.
Oh, without question. And not only from cities and agencies, but also from bondholders. They would have
Absolutely,
had
that's
the
where
best
that
case.
class would come.
And so the bonds that were issued in 11 are kind of out there?
Still
or-
kind of out there. Moving on to the submission of ROPS provisions in AB 1484, the January to June ROPS, which is the next ROPS, we can refer to it as ROPS 3. Originally, this was to be presented to you in October and sent over to the Department of Finance in October, November, so that the DOF and the county could review and do their calculations so that we would receive funds in January. This bill moves this timeline up, and so the ROPS for January to June 2013 must be sent to the Department of Finance by September 1st. What that means is at our next meeting in August, we have to bring that to you for your review and approval so that we can make this September 1st deadline, because your September meeting isn't until September 5th. So at our August meeting, we will be hurrying to prepare it over the next couple of weeks and bringing it to you in August for your consideration so that we can be in compliance with this section. If we do not do that, then there are $10,000 fines for every day that it's sent late to the Department of Finance.
Aren't they a little loose with their fines? Literally, I mean, they can take all the time they want, even in preparing a budget up there, never being on time. There's no fines associated with that. But if we're a day late, they throw everything at us. Albert, you had a question?
I have a question, just a comment. I think at some point we need to clarify what we're doing here, first of all.
Yeah.
I think Mr. Ochoa is right. First of all, we have to first clarify. I got a letter from the county saying I'm immune from any and all lawsuits if I'm doing my job as a fiduciary here. The minute that I'm outside of that fiduciary duty, I could be sued by any member of the public. I didn't take this job to be sued by anyone, so I want to make sure I take my job as a fiduciary very seriously and don't want to be sued by any member of the public, and I want to be immune from anything. But I approved our ROPS 1 and 2, not knowing what I was approving, to be very honest with you. It came in the last minute for all of us, I think. We didn't have really a lot of time to review it, didn't have a lot of time to look at it, so we approved it just to move forward with the process. For me to review ROPS 3, I would need at least a good 2 weeks before it's submitted to me, so I can say that I've done my fiduciary duties of at least reviewing it, if not technically, but that. So I would ask that we get the documentation at least 2 weeks in advance of an actual meeting. This way, we will have enough time to at least review it before we come in here, already have approved ROPS 1 and 2. So that would be my suggestion, if we're going to do that, to get it a couple of weeks in advance so we kind of say we've reviewed the whole thing, and then by then I'm hoping, I'm praying that by then we would have a legal counsel write a letter to the state and get some kind of response back from the state so we know what we're doing, and then everything will fall in its place.
Do we expect, on that point, I don't disagree with that one bit, do we expect a whole lot of variation in these ROPS?
No, most of the hard work was done when we prepared the first two.
Constructing us, I think it's more than appropriate and more than fair to say we need to have this 2 weeks out.
Okay.
Let folks go over it, make sure that we're acclimated to what the numbers are.
I have to check with our legal staff to see if you receive it 2 weeks in advance. Based on this, if the DOF and county must also receive it 2 weeks in advance.
Okay.
But we will endeavor to prepare it as quickly as possible and send it to you. This is the last section I'll highlight. This is called the Long Range Property Management Plan, and this section requires the successor agency to develop a property management plan that governs the disposition and use of any agency property from the former redevelopment agencies. Let's see. So we will be preparing that long-range property management plan and bringing it to you for approval. Okay, so this
That's
is
1484 now?
This is also 1484, yeah.
And we can find out what 51 and 50.
Yes, 1151 and 56. First, I'll go to 1151 and
Mr. Chair, can I ask just one, hopefully it'll be a quick question, but I think on the property management, the question I get more than anything else from folks is the disposition of property assets like the Alex Theater. what do we think, I don't know that we know yet, what do we think the trailer bill does to those land assets like the Alex?
This bill did add a couple of other types of uses, such as police stations and some other uses that can be transferred over to the city. However, it did not include cultural facilities, which is what the Alex would be considered. So to answer your question, we still don't know. By preparing this management plan and bringing it to you for review, and further reading and analyzing AB 1484 might provide some answers to that.
I had a question.
Sure.
I think I missed the date that the audit for the cash balances had to be complete.
The 9th, I think it was, wasn't it?
I don't have it in my summary. I do have it in the bill. I'll.
That was the 9th, though, wasn't it?
No, that's for the.
Pass-through, wasn't it?
Yeah, that's for the county to do the calculations on the pass-throughs. The CPA. If you'll allow me to look into it and get back to you in a little bit. SB 1151, which was authored by Senator Steinberg, this establishes a Sustainable Economic Development and Housing Trust Fund, and it's to be administered by a Sustainable Communities Investment Authority, so it would be a new authority that'd be put together. This bill is currently postponed, and as I read the summary, the funding source for this is unencumbered balances and assets of the former redevelopment agency. Following my summary of AB 1484, that's the same source of funding, so I don't see how this bill could be passed and implemented if the sources of funding are already up for grabs in 1484. So I don't believe 1151 will continue.
Didn't they indicate, they meaning the legislature, that there was going to have to be cleanup legislation for the trailer bill?
For 1484?
Yeah, the cleanup bill has to be cleaned up? I mean, is that, those two bills supposed to handle that?
No,
Oh,
no.
okay.
And if you
They're
read the
supposed to follow
LAOs,
it, aren't they? They're supposed to follow the 1484 cleanup.
well, 1484 was to clean up AB 26, but as Mr. Ochoa stated, I'm sure these tight, aggressive schedules might be difficult for some agencies to comply with, given that some of them are having half or very few staff starting today and have to comply with these deadlines. So there might be some cleanup legislation to 1484. The LAO's, the Legislative Analyst's Office review of 1484 also indicated that the projections of revenues from redevelopment agencies were extremely high, and that there are legitimate debts from former redevelopment agencies. So even the LAO predicts that those revenues won't materialize.
And at this point, we're one of two states in the union without tax increment finance. Us in Arizona.
Yes.
1156, again, authored by Steinberg. There's a hearing for this legislation today, and this would form a Sustainable Communities Investment Authority and would require the authority to adopt a plan for sustainable communities and authorize that in this plan the receipt of tax increment funds. So it's redevelopment.
You've gotten rid of
2.0.
redevelopment and you're...
Yeah. So there's a hearing on this today, so we will provide you an update at the next meeting. That concludes my legislative update, and if there are any questions, I'll take them now. If not, we can move on.
Any further questions? I guess not.
At 4 is action items. 4A is Director of Community Development regarding selection of outside legal counsel to represent the Oversight Board. At 4.8.1 is resolution directing Successor Agency to negotiate and execute a contract for legal services with the firm of Green, de Barnowski, and Quintanilla.
Board members, the selection of legal counsel was placed on earlier agendas. This board decided to have their own legal representation, independent of Ms. Van Meiden, who's the legal counsel for the Successor Agency. We issued a request for qualifications. We received 9 responses. At your last meeting, You reviewed the 9 responses and agreed to move forward to the short list 3 firms based on city attorney's internal review. The 3 firms were scheduled for interviews. 1 firm decided to withdraw because they already represent oversight boards in other jurisdictions that also meet on Wednesday afternoons, so they would have a scheduling conflict. This body also recommended a subcommittee made up of 3 members, Chair Raggio, Vice Chair Lanzafame, and Member Ochoa, to interview. And upon interviewing the 2 firms, the 3 of them are recommending for this board the appointment of Green, I can't pronounce, the Pentowski and Quintanilla to represent the Oversight Board. So at this point, if you'd like to ask the subcommittee to make any additional comments before your vote.
This firm had a retainer fee built into it, a $3,000 something retainer fee. I think, with a $12,000 budget, it's going to be exhausted in 3 or 4 months. I don't know how many hours we think we're going to need this firm, but if we went on time and material rather than a retainer fee, would we save money by doing that?
As I understand it, and correct me if I'm wrong, but that was a retainer fee to be put there and then drawn against, and there was no limit in terms of time with respect to it, so that if we needed a few hours now and a few hours later, and their per hour rate was in sync with the others, if not, I think a little bit lower. Yeah. And also that my rationale for the vote for this particular firm was they have had a lot to do with the Finance Committee in Sacramento, and at times have been successful. And I thought, there's a plus, because it seems like the bane of our existence at the present time happens to be the Finance Committee in Sacramento, or the Finance Department. But I thought overall the result was that their fee structure was compatible with others, and that they did have the edge with respect to their knowledge of how the Department of Finance operates.
Yeah, I'm not questioning the quality of the firm. When I read it, it said a monthly retainer of $3,300.
No,
so if we negotiate something different, that would be fine.
It was time drawn against it, and it would be carryover, and they specifically said it would be carryover.
Okay.
My recollection is wrong.
Other questions?
If there are no other questions, then I would move item 4A1.
Second.
All right. Roll call, please.
Board members Abkarian? Abstain. Okay. And Lansifan?
Yes.
Nakasone?
Yes.
Ochoa?
Yes.
Sheehan?
Yes.
Steger?
Yes.
Chair Raggio?
Yes. The action passes. Next item, please.
At 4B1 is Director of Community Development regarding California Department of Finance approval of recognized obligation payment schedules. At 4B1 is resolution acknowledging receipt of Department of Finance approval of recognized obligation payment schedules.
Board members, this item is being presented to you at this meeting because we simply didn't have enough time to bring this. Ideally, we would have brought this DOF approved ROPS to you prior to receiving our distributions from the county. Unfortunately, with the letter from the Department of Finance being received on May 25th, we were unable to agendize this item for your May 30th meeting, and so it's being presented to you today. This just acknowledges that you received the ROPS as approved by the Department of Finance, and the 2 items that were disallowed by the Department of Finance are the city agency loan and also the 20% housing set aside.
Questions?
How much would the total of loans by the city?
Mr. Abkarian asked a question about the amount of the city agency loans. It's over $40 million, and for the 6-month ROP schedule, we were proposing to pay that down by $6 million.
It had been a $6 million a year obligation on a total 70-something, $72 million, I think, loan. The city, as I recollect, the agency paid back the city last year $32 million.
Correct.
And then there was a remaining balance of $40 million that has to be written off.
Correct.
And if that is ordered, the 32 million is ordered back, we have to write off an additional $32 million. Is that correct as well?
Correct.
40 million was written off by the city? Of
It
the
will be.
loans?
Will be.
It will be. So and it was, I mean, it was real money that was fronted by the city to the agency. Interest-bearing, regular payments, the whole 9 yards, fully, all the different loan terms. And the city had repaid a big chunk of that last year, and if that gets clawed back, that money, hard cash, is gone, and then the books will have to scrub another $40 million on top of it.
And just for full disclosure, the city, as an entity, is still weighing its ability to litigate that issue under contractual obligations. The reason we're saying it was noted as a write-off is because under general accounting principles, so if there's a statute out there saying that that's no longer valid debt, for purposes of governmental accounting, we have to write it off. But that doesn't mean the city has necessarily waived its right to receive that payment. We may still move forward with litigation. We really haven't decided that yet, but and at the time we do, it'll be something that gets announced publicly. But that's the reason it was written off, because there's a statute saying it's no longer valid debt.
At the preparation of this agenda item, we indicated that we would bring back some revisions to the ROPS, because if we do have to undo the cash, then some of these funding sources change. However, in light of AB 1484, at your August meeting, you must also review ROPS 3. And so you will receive both schedules for your August meeting.
All the more reason, I think, to Mr. Abkarian's point,
Correct.
that we get that early.
And a lot more time for that meeting, probably.
In the report, it indicated that we asked for $19 million for ROPS 2. And we received just under 13 million. So what was approved and what we got was $6 million. What isn't in the report, and I understand why, it's already taken place, but in ROPS 1, how much did we ask for that we didn't get?
So for ROPS 1, our request from the RPTTF, which is a Redevelopment Property Tax Trust Fund, was over $27 million. And we still contend that that's money we have not received. As I indicated earlier, the LA County and the Department of Finance feel strongly that they distributed those funds back in December to us, and that's why they're going to be doing this review of the pass-throughs to see what they gave us and what, if anything, is due. But there's $27 million worth of obligations that we believe from January to June that we have still not been paid for.
And is there any penalties if it's found out, yes, they didn't pay you?
No.
We've got obligations, we being the successor agency, and this board overseeing that successor agency, obligations of $27 million that we didn't get funding for, because with December, you were looking back.
Correct.
And with June, you're looking forward.
Correct.
And so there's a 6-month gap where no one's getting paid.
Correct.
I have a question, and it's the item 3 page 3 of 8, and that's the Alex Theater lease, and as well as the management agreement that went along with it, and our response to DOF. Would you clarify that to the extent that
Sorry,
it's possible?
which item were you talking about?
The Alex Theater lease, and it indicates that the Department of Finance moved the Alex Theater lease listed on ROPS 1 and 2, line item 22, to the administrative cost sheet.
Mr. Chair
I'd like to
Rajo,
understand what that means.
Chair Rajo is referring to exhibit, I believe it's exhibit 3. And this is a memo that Ms. Van Meiden and I prepared in response to DOF's first review of our ROPS. And the way AB 26 reads is some general wind down of the redevelopment agency is considered administrative in nature, whereas other ROPS items are project specific. And so in their brief reading of the line item on the ROPS, they viewed that as administrative in nature, and our response was that no, this is actually a specific project with a redevelopment asset. And so we clarified that the lease obligates the agency to perform a number of capital improvements to the Alex Theater, and the management agreement also has some compliance that we must monitor. And so after clarifying that with them, they agreed to leave it on as a project as opposed to an administrative function.
So as a project, then, it will have a completion date
Correct. The lease is
and a cost associated with it.
correct. Correct.
Did that funding source change from the tax fund to cash?
No, it did not. But unfortunately, all we got was enough to just pay our debt service. So as part of the revisions, I was referring to the ROPS that will come back to you at your next meeting will include using some of our cash to pay for that, because we have to meet that obligation regardless of we got enough tax funds or not.
And the Department of Finance is in agreement with the use of that cash?
Correct. Correct. Yes.
And so that's what we'll see next time in revised ROPS.
Correct.
That rather than property tax fund, we'll say cash. This board will have a chance to review it and approve it. Then it goes to the Department of Finance. They'll, in effect, be reapproving what they approved.
Correct. And if I can close the circle, one of the reasons I believe the LAO, Legislative Analyst's Office, their review says that there aren't enough revenues that will materialize is because the governor's office was counting on some of this cash, and just as you indicated, we need to use that cash to pay our obligations, so those revenues will not materialize.
Further questions? I think we have to take action on this item as well.
We have one speaker card.
So, don't we have to approve this? No?
I think you have to have the speaker who wants to speak on that first before you approve it.
Oh, okay. Mr. Cassandra.
How long?
3 minutes. Is
Good
that?
afternoon. My name is Aram Kazazian. The reason I'm over here regarding item number 11 on Exhibit 5, the Comar, I do have a big problem with that. That project was originally approved with 325 parking spaces plus the 60 parking they're replacing many years ago. Then about 60 days ago, behind closed doors in the council chambers, that overnight in just a one-night event, that was dropped from the required of 325 plus 60 down to 39 parking spaces. And they claim they're going to lease 70 spaces at the Maryland parking, which is the maximum they could lease over there, and that lease is only for 5 years, I understand. I have not been able to obtain the documents. I've asked for it. I have not received it yet. And then we come, they have conference rooms. The conference rooms itself requires somewhere about 390 parking space. The hotel requires 173 parking space.
Pardon me for interrupting. Isn't this something you should take before the successor agency, or haven't you already done that?
I have already done that, but this is also a matter of your approving on this money here. It has a lot to do with it because we do have some irregularities, I should say, and there are some potential problems here that can come up. Even the handicap parking is not not to par. According to the U.S. Department of Justice, they don't even have the sufficient parking for the handicap in here in the building. So we have a lot of problems. If you're going to approve something like this board should be responsible for not doing correctly. I'll come back again in my 5 minutes. I got a lot more to say if you want, but I think there's a big discrepancy, big problem on this project. The land is owned by the city, and we're letting them build it on a lease, and then they have the right to purchase the property. Yes, they do have that, and we don't know how much. It's not disclosed. I've asked for the documents. I have not given any of the development agreement documents. I have not been provided. I'm still waiting for that. So hopefully I'll receive it so I can bring you more.
Thank you. Mr. Garcia, would you advise the Oversight Board as to what we can do about this? Is this within our purview?
Again, I'm not, with the caveat that I'm not really your advisor, but our view is that the land use issues and the parking issues are issues that are within the purview of the city and the city council. And as you intimated in your comment, your initial comment, that's really a question for the city council and the successor agency. The question before the successor agency, with the oversight board, is whether or not that debt that's listed on the ROPS is really an enforceable obligation. And my response to that would be that yes, it is, because that was an obligation that was entered into by the redevelopment agency prior to the dissolution act becoming effective.
And the Department of Finance has reviewed it and approved it, as
Correct.
well as this oversight board?
That's correct.
And my contention is that it was approved on a obligation prior to changes. So once they did the changes, this is a brand new project. It is not the same project that was approved under the development agreement originally.
But the issue is whether we have the right or the responsibility to do anything different than approve what is here, because we're only talking to finances.
Well, I think your board does. I'll go down to the county supervisor if I have to. I will do that next meeting, but I think you do. If you approve this, you're still obligated for what you're approving, something that's not legal, especially according to it not even being approved for the U.S. Department of Justice. The handicap parking has not even been approved accordingly. They only have 2 parking handicap, which was required minimum of 8 up to 12, so even maybe could be. Thank you.
Just a quick comment in here. My understanding, Mr. Kazazian, is that we will approve the line item or remove it from approval and move it somewhere else. We have my understanding is, God knows, still don't know exactly what our authority is, but I'm sure we'll find out soon. My understanding is that we have no authority as to what the city does in reference to the parking, in reference to the zoning. Overreaching is overreaching, but this is as much of an overreaching as I've ever seen. We don't have any ability to do anything like that. It's my understanding. So city is operating as a city, and this agency has no authority to, in any way, shape, or form, interfere with the operation of the city. Our job is to see if these line items are right, and then based on those, take action.
It is a redevelopment money, sir. That's what the development funds, public funds, we're giving away for free. And we're putting a 173-room hotel. The hotel is being built in Narua Marriott is being built downtown. That is 174 rooms, and also over 500 parking spaces. That's the Marriott Courtyard again.
Mr. Chair, I think Mr. Adhikarian's point is very well taken. I'll call for the question.
I'll move item 4B1.
Second? Any further discussion? If not, roll call, please.
Board members Abkarian,
Yes?
Lansifin,
Yes.
Nakasone,
Yes.
Ochoa,
Yes.
Sheehan,
Aye.
Steger,
Yes.
Chair Raggio.
Yes. Passes.
Chair Raju, if I may go back to a question asked by member Nakasone in regards to the certified audit. Mark Berry of our staff quickly looked this section up, and it's 34179.5, and the review must be completed by October 1st, 2012.
That wasn't the date that was changed back to September, was it?
No.
Okay. Thank you. We're to oral communications now, and Mr. Kasaja.
Oral communications discussion is limited to items within the jurisdiction of the Oversight Board. Each speaker is allowed 5 minutes. Members of the Oversight Board may question or respond to the speaker, but there will be no debate or decision. The matter may be referred to staff through the Executive Director of the Successor Agency for investigation and report.
Thank you. Now, I understand that there is a almost $1.1 billion, that's billion, not $1 million, of obligations by the redevelopment agency to the state. Now, what is going on with this money? How is this going to be paid? I also understand that there's a $315 million obligations from the redevelopment agency to the Glendale General Fund money that they have taken to pay payroll for the redevelopment agency over the many years. They've removed the $315 million out of the general fund. And is this money going to be ever paid back, or it's a forgotten, or is it a gift, or what is it? That's a big concern I have on what's going to happen here. And where was the previous city manager that did not pay attention all this was going on? With $315 million depleted of the city funds, and nobody said one word about it. This didn't even come out until Brown stopped all this. I mean, this is something big. This is crazy. This is much bigger than we're talking Comar. Comar is going to get away maybe with $10 million because he's a billionaire. So I guess we can give him all he wants to. Somebody rich like that. And the Marriott says 174 rooms. They got 600 parking spaces over there, their building. And this is 173 rooms with 39 parking, would they legally have to have 8 minimum handicap, according to U.S. Department of Justice. I have the letter. And, we're ignoring all this. We're approving something that's illegal. The Department of Justice says even if you knowingly approve something illegal, you're really not, it's illegal to even for the city to approve a project without the proper handicap access or handicap provisions. Not just approve it and say, well, we get caught later, we can get fight for it. But a brand new project, 39, they said, well, we can park people on the aisles. We're going to park people on the aisles, and you cannot block handicap parking space. They want to block handicap parking space, 39. So you can take 70 parking to the Maryland parking structure. And we went to a wedding the other day. There was 370 people there. The place over there had a total of, I have the count of the parking. They had a total of 370, and they had 185 cars that was there, and they parked a total between the band, singers, management, the wedding coordinators, parking attendants, waiters and waitresses, and cooks, and the cameraman. There was 249 cars. They only had 200 parking spaces on site, which is pretty good for a banquet facility. They were very well equipped, and they still end up with almost 30, 40 parking spaces in the street. And we're talking a banquet room of 400 people in this facility with no parking. What's going to happen? Wilson, all the residential is going to be taken out. And women with high heels, they're going to be walking in the rain and the cold in winter or the hot summer into a hotel, and they don't consider all this. I don't see how even Marriott would even consider something like this. This is more than politics. It's unfortunate. I know all these people, but it's not right for Glendale. I've known Komar. I've known every one of them. Shervanian's on. I'm Nazavan Hanesian. I know all these people, but it's not right for this body or the city council body to undermine the city's well-being for all the future with a big building like this with no parking. I don't believe it. It's mind-boggling. Thank you.
Mr. Milano.
Good afternoon, members of the Oversight Agency and staff. My name is Herbert Milano. I have been trying to put my arms around some of the functions of the Oversight Agency and see the relationship of the oversight to the Successor Agency. And I found on the web a fairly good substantive document with questions and answers by the Oversight Board in the city of San Francisco. So in case anyone still has any questions and wants additional clarification, I think they did a pretty good job in trying to bring about some of the key issues and responsibilities of a board such as this one. Among them is the idea and the authority to terminate agreements and provide funding for the debts, things that some of you have already discussed here. I would like to know if there is a location where I can find some type of comprehensive financial report that would allow the general public to get a clear understanding of what the current financial status is of the Successor Agency, such that we can follow the proceedings of this board with regard to the future obligations that it has. I have some that are not significant but may be worthwhile, especially for the school district. Redevelopment Agency lent a couple of $1 million, if I recall, several years ago to the Glendale Unified School District for purposes of developing the field, the Moyes Field in Glendale High School. Other cities, like the city of Burbank, it's an outright grant. They just simply gave it to them. They recognized the mutual need of such of their artificial turf, but Glendale didn't do that. So it appears that the GUSD has an obligation to the redevelopment agency. I personally feel that the city should basically write it off. But nonetheless, it is part of the overall structure, I think, of the purview of this oversight board. And I would like to see if this board can authorize maybe the issue of a financial statement that we can all follow in some detail for those of us who have questions about items that I just exemplified. Thank you.
Thank you. No further speakers? Do we have any comments from the board?
I would like to make a couple of comments, if you don't mind. First of all, I understand that we are to review something in early August for it to be presented to the DOF on September 1st. Wouldn't it be better for us to meet at the end of August, closer to the deadline? This way we have resolved some of the issues. There might have been some other letters. I mean, things that happen in this thing on a daily basis. The closer we are to the date, the better it would be. Instead of having a meeting on August 1st and then having one on September 5th, just have one meeting at the end of August and then you would not have even any meeting on September. This way we can have just one meeting for August and September and cover everything, and could have a longer meeting in August.
What's the pleasure of the board?
How does staff react to that?
It would certainly allow us more time to put together the RUP, so before that, if it's the pleasure of the board.
And how does the board feel about that?
It's something that I was thinking about also, but then I also thought that if we needed to have a subsequent meeting in case something happened, then we need enough time to do that too. So I was torn between whether or not to have one meeting at late in the month or push through the first part of August and then leave time to do something at the end. So I don't know.
We could have a whole new synopsis of legislation changes by that time.
I think the die is pretty much cast as it is for the time being, so I think it's a good idea.
Gives the staff a little bit more time to prepare everything. It's closer to the date, so if we need something 2 weeks in advance, it won't put any pressure on them to actually have something to us on a more timely basis.
With the caveat that you need your materials about 2 weeks preceding that meeting.
I'm sorry, say that again?
Yeah, with the caveat that you need your materials about
Yes.
2 weeks preceding that.
At least 10 days before. I mean, just one weekend, a full weekend before, so we can take a look at it. I mean,
Mr. Chair, I might, following in Mr. Steger's suggestion, though, I might propose August 22nd, Wednesday, August 22nd. If there is some follow-up, it gives us the 29th before we start incurring $10,000 a day penalties. So maybe the 22nd.
Is that agreeable with everyone? We're talking about the 22nd now, the afternoon of the 22nd, and that's a Wednesday?
yes.
All right, that doesn't take action, it's just,
We'll note it and get it on the calendar.
very good. And should we have our attorney at that meeting, our new attorney?
Actually, that would also give us additional time to select and negotiate the contract so that they can be at the August 22nd meeting. It would be a little difficult to get all that done for August 2nd.
And then I would also say that by then we would actually have paid them and there are attorneys. Could we, before that meeting, ask them to clarify a few issues with the state so when they come here, they would actually have a report as to what our responsibilities really are and just kind of go over that so we're not as confused as we are now?
The benefit of selecting the firm that you selected is that they already are experienced in representing other oversight boards, so I feel they would be prepared to answer those questions
So we
at
would
the
need a
next
report on
meeting.
that date also as to our responsibilities and what we can and things that we can't do. This way, we won't do things we can't do. We won't even review them.
Is there any further business?
Chair Raggio and members of the board, I just want to remind everybody, unfortunately, I don't have a list in front of me, but those who have not submitted their Form 700s, I need those. If you can today, you can come down to my office and we can fill it out, or if you can get it to me this week.
Thank you. If nothing else, then I'll entertain a motion for adjournment.
So moved.
We are adjourned.
Who seconded?